Hey, friends. Welcome to Dishing on Divorce Tuesday edition on WGSN-DB, Going Solo Network Radio, Podcasts, and TV. I'm your host, Lisa Lisser, CEO and founder of LZL Coaching, a boutique coaching firm focused on divorce, relationships, and life transitions. I'm also a divorced mom of 3 now grown kids, a recovering lawyer, current educator and spiritual counselor, and a divorce coach who is committed to transforming the divorce experience for everyone involved. Although it may seem like the system is broken and there is no one on your side to help, I have met a few really powerful individuals who see what's broken and are committed to fix it. Today's guest, Carolyn N. Daly, is one of those people. Carolyn first reached out to me because she wanted to build a network of professionals who were engaged in the hard but necessary work of doing things differently. That's what motivates Carolyn. If it's not happening right now, she wants to make it happen. Carolyn is a New Jersey Supreme Court certified matrimonial law attorney who prides herself on her pragmatic, no-nonsense approach to resolving family law matters in a manner that best serves her clients and their families. And I have to tell you, her no-nonsense approach is what totally drew me to her. Her energy is what is so powerful. Prior to establishing her family law practice, Carolyn gained experience in several different areas of law, which gives her a unique perspective that allows her to identify issues that other family law practitioners often overlook. An active member of the family law community in New Jersey, Carolyn is involved in several family law organizations. In fact, she's a past president of the New Jersey chapter of the American Academy of Matrimonial Lawyers, and previously served as secretary, treasurer, and vice president. She's a member of the New Jersey State Bar Association's Family Law Executive Committee and served on the New Jersey Court's Supreme Court Family Practice Committee. Carolyn is a frequent speaker and author on various family law topics, and she's been featured in numerous publications, including Mendham Neighbors, New Jersey Family Magazine, and New Jersey Family Lawyers. Welcome, Carolyn.
Thank you, Lisa. I am so excited to be here. You and I are going to have a fun next half hour, 45 minutes, because we don't really need an outline. We just seem to talk about the issues as they are and just sort of go back and forth as to ideas as to how to improve them.
Yeah, that's what always sort of like connected us, like our conversations flow. So Let's get started. Tell me what brought you to the family law space, right? Your bio says you did different things first. So what drew you to family law in the first place?
So it's very interesting. I would say that I did not pick family law. Family law picked me. I truly believe that I did practice in many other areas. I was in civil litigation. I was in criminal litigation. I did real estate transactions. I did a number of other areas, including family law. And then little by little, as my career progressed, I ended up working more and more in family law. And I had more clients come to me, more professionals come talk to me. And so little by little, the other areas sort of got phased out. And the one or two times that I tried to maybe make a change and go in a different direction in terms of my practice area, family law just drew me back in.
Right. Okay. So what do you think it was about family law that drew you back in?
So I think it was largely about the ability to help people in something that is really fundamental for them. I mean, families are the fabric of society. And if we can't serve them better, then we're sort of failing. And so, whether company A versus company B, somebody gets an injunction, somebody gets some money, I really on some level don't care. But whether somebody actually is able to move through a divorce process and arrive on the other side as intact as they can be with them, their family unit, their kids, that's what's really more important. And that to me is something that really impacts people on a personal day-to-day level.
So I love that, because when I got involved in this, it was really about helping people at their core. And when you talk about families, family is the core unit of society. And if that is fragile and vulnerable, then we're all fragile and vulnerable. And so sticking with that when it may be the most challenging, when people are at not their best behavior, perhaps, and it can really wear on you. But sticking in that environment is really noble in many senses. So, thanks from the rest of us who have to go through the process. Um, but one thing that has stuck with me about your practice is your awareness that something really isn't working in this space. So tell us a little more about that.
Sure. I mean, I think that most practitioners would tell you that on some level the system is broken, and I'm not going to point at one individual piece of it. It's just as an overall system in terms of helping people resolve their cases. We are not doing this as effectively as we were many, many years ago when I first started in practice. I have the statistics that I looked at from the end of the court year, which is June. Our court year ends in June. So the June 2024 statistics in terms of backlog for divorce cases, they call them dissolution, but divorce cases are, 20% upwards of 150%. So we're not even making a dent in what is currently being filed statewide. And part of the difficulty there is that we have been operating at a deficit of judges for an extended period of time. And it's not the pandemic. It existed and occurred prior to the pandemic. And, I don't think the public really appreciates or is aware of that pretty much at any given time, we are down 20 to 25% of judges that we need to fill the entirety of the complement of a bench, which then stresses the rest of the system in order to be able to reach cases and clients and to handle matters efficiently, effectively, and with some level of thought. It's just very difficult. And so people tend to see it as, okay, well, we have judges who are appointed in New Jersey. So, the judges get appointed and they say, okay, well, now we filled the deficit. Well, no, because between the time you appointed the new judges and now these other judges have retired or been elevated to the appellate division or left the bench. And so we don't ever quite get to a full complement. And that just makes things very difficult.
Yeah. And people think they're going to get their day in court. But when we're still operating in this deficit situation, we never have a full complement. So the waiting game goes on.
Right. And you're never going to, the reality is that you're never going to get to a point if we continue in this deficit and we continue with the backlog, you're never going to get to the point where judges can, when I started my practice many years ago, I won't tell you how many, I would get trial days that were consecutive. I'd start a trial on a Monday and we'd go Tuesday, Wednesday. Maybe I wouldn't get the entire week, but I would get more than one day. And at the present, when I have a trial, and I have one now, the case is 4+ years old, I'm not even getting a full day. I'm in court all day, but I'm being interrupted in the trial for the court to be able to handle emergent matters, other issues. There's a meeting that came up, something that happens. I just, I don't know how judges juggle it all. And there's just not enough hours in the day for them to be able to reach every case that needs to be resolved. And the difficulty then becomes cases that might have been really easily resolvable, right? That you could have reached and gotten resolved now get old, and people get really entrenched and they get angry and they don't want to resolve their issues. And they think, no, never mind. I'm just going to wait now for my day in court. And they don't realize that costs them emotionally, financially. It wears on their children if they have children. It wears on the extended family in certain circumstances. I have a case now where extended family was pretty insulated on both sides and pretty supportive of both sides. And the case has lingered for a number of years now. And, in-laws who would have dinner with in-laws, right, they're not doing that anymore. And to me, that's just such a failure because there are grandkids involved that will have graduations and weddings. And the dynamic that existed with people who were very good and had preserved, really Herculean efforts preserved, it's falling apart. It's just not necessary.
So what do we do? Right? What do
Yeah.
we do? Like, because one of the things, as I said right at the beginning, is you're looking to make change. So what is your sort of vision of what we can change now, and what is your hope for what can happen?
Yeah, I think on an imminent basis, I think that the public really has, I think they hear the words that we talk about for alternate dispute resolution, like mediation and arbitration and collaborative divorce and parent coordination and all of these processes that provide for alternate dispute resolution, but they don't really know what they are. And I don't know why that it's not explained. I've spent a lot of time writing articles about it. I lecture, I speak to people about it, because if we are going to have a system where we don't have a full complement of judges, then we have to look for a way outside of the system itself, permissibly, right? A permissible way, alternate dispute resolution outside of the system itself, to allow parties to resolve issues more quickly, efficiently, effectively, confidentially. And so we talk about things like arbitration. Arbitration is not used a lot in New Jersey in family law, and it should be. There are cases that date back to the 80s that have said we should be using it, that we can use it. We have not yet adopted the UFLAA, which is the Uniform Family Law Arbitration Act, and several states have. And it's designed specifically for family cases. It actually, is a much better statute that we could be using. Right now, we use 2 civil statutes to arbitrate if we arbitrate family law cases. And I know that the Family Law Executive Committee is looking very hard, very closely on ADR methodology, and we'll be talking about this. But, arbitration is just so much more confidential, right? You get, first of all, it's a private process. It doesn't go to court. Things aren't filed in court. If you have sensitive issues or cases or documents, your income, your finances, your children's issues, your issues, why would you ever want to put that in front of a judge in a courtroom, right? On a record. You get to select your judge. They're called an arbitrator, but you get to select the person who is going to decide your case. And that person is hopefully either, someone who's got 20 plus years, 15, 20 plus years of experience in family law, which we don't have the luxury of in terms of all the judges that sit in family. Not all of them have ever even practiced family law. And so, you have something that's complicated. You may not want to take it to court, wait 5 years. You may want to go quickly. The other thing that I think in family law that we don't use, motions are taking months to be decided. You could arbitrate a motion. It's a simple process. I've actually developed, the administrative office of the courts approved it. I developed a program for them to do that. Hasn't been implemented yet, but there are several counties that are months out in terms of deciding things like, he terminated all the financial support to me. How do I get financial support? You're waiting 3 months. You can't wait 3 months. We don't have a parenting plan, but we're separated. And now you wait 3 months. You can't do that. That doesn't help. And so arbitration, you get in, you could do it in an afternoon, be done, have a decision, and move forward. College contribution is one I see quite often, right? Parties don't, in their agreements say, we're going to contribute, perspective to our income and whatever it is, but there's no percentage set forth. We're just going to address it at the time. The court doesn't have time to have a hearing about that. They have full-blown custody cases and domestic violence cases and divorce cases. So, that's going to wait. By the time sometimes it gets heard, your kids are in college.
Yeah.
And you don't have a decision. You can handle that type of a case in arbitration in a day or two and be done. Termination of alimony, right? Whether it's cohabitation, whether it's retirement, again, that's a post-judgment issue that when we have a system that's already stressed, they don't have the time to do that. So why not go into this process of arbitration, this alternate dispute resolution process, where you're going to get a decision quickly with someone who has the experience and in the long run probably cost you less money than if you're going to litigate it. And you can, most of the time when you arbitrate, you don't appeal. So it's final. It's
Right.
final. You're not in this endless process of, I try to explain to people, they're like, well, I'm going to go to court and I'm going to have the court decide. And then if I don't like it, I'm going to appeal. Okay. Yeah, you're right. That's your option. But you do realize the appellate court is not a court of final ultimate decision. They're just going to say the judge got it right or the judge got it wrong. And if the judge got it wrong, you get a do-over.
Yeah.
Why would you want to do that? So there are really a lot of benefits. And in New Jersey, we now have forms. We now have people who do arbitration, people who have been trained to do the arbitration, and you enter into an agreement and you start the process and you work through that process. The other thing I think people don't think about in terms of arbitration is you decide what that process is. If you want it to be just like a full-blown trial with rules of evidence and formal discovery and everybody comes in and testifies, fine, you can do that. But if you want to do it where the rules of evidence are relaxed, we're gonna handle, certain things. We're just going to stipulate the documents in. We're going to put this information in directly. We're going to have a more abbreviated, questioning. Maybe we're going to submit a lot of documents to the arbitrator, let the arbitrator tell us what they still need. And maybe we do limited testimony. You can focus, you can shorten this whole process and get decisions. And I think if people, the public and other, if litigants in the public and really understood the benefits of this, they would choose it. They would run to it.
Yeah, no, that sounds amazing. I mean, it's something that I have never discussed in depth with anyone. And this could be the first time that our audience is hearing about it. So let's put it on pause for now. We're going to take a quick 30-second break, and then we'll be back and learn a little bit more from our guest, Carolyn N. Daly. And we'll be back.
Thanks, Lisa.
And we're back with Carolyn N. Daly, who has just given us like a whole tutorial on arbitration. Now, arbitration is this alternate dispute resolution process that we don't talk about that much. We talk a lot more about mediation and a lot less about arbitration. But it sounds like arbitration is more of a trial type process, because your arbitrator stands in the role of a judge who is making decisions, where a mediator stands as a neutral who is sort of
facilitating
like the volleyball.
Yes.
You say this, how can we come to agreement? But when you go into arbitration, you are actually allowing someone else to make the decision, because you're recognizing that the two of you actually can't.
Yeah.
And maybe that's why you're in this situation in the first place.
Yeah.
I remember when I was going through my divorce, that it was so frustrating to feel like every time we had a motion, and we didn't have that many, the judge would throw it back to us to say, enough already, you decide. And it was so frustrating because we couldn't decide, which is why there was a motion.
Right.
And two people who were at their wits' end and who could not be in the same room together were now being told, you have to decide.
Right.
And
go out in the hallway with your attorneys and see if you can work this out. Or, you know what, I'm going to send you to mediation and let's see if maybe the mediator can help facilitate some sort of a resolution. But oftentimes people have been through the mediation process. I mean, I try to take my clients into mediation pretty quickly into a case, because I just recognize if we're going to need some assistance facilitating, let's get there started. I don't need to wait. I know how mediation works, and we can talk through some of the issues there. But the same thing with arbitration. You have if you hire an arbitrator, if you really truly believe you're going to need someone to make decisions, if you hire an arbitrator early on, you can get to that arbitrator can assist with discovery. Like, what do you really need, instead of the 400 interrogatories with subparts that really have nothing to do with your case?
Right.
I mean, I cannot tell you the number of time I get what I refer to as the form interrogatories, and they're not even, they have somebody else's name in them.
Yeah. Yeah.
They
I
have
mean,
different children's names in them.
let's take a little bit of a pause, because people might not be at that place yet where they even know what interrogatories are. So
Okay.
interrogatories are a written form of discovery that
Correct.
are the questions that one side asks the other side to get information. Now, they may be a form, like 80 pages of formulaic questions that may be standard that law firm asks every single opposing side. And they may have nothing to do with your case. And they may not even have your name on it, because they were just copied from the last case that law firm was working on. Or it could have been a junior associate who just said, take that model, whose senior associate said, take that model and just cut and paste. So all of that could be part of your experience. And then one side gets offended at the other side because they're not paying attention, or the lawyers don't get offended, but the clients get offended because the clients are feeling like nobody cares about me and it's not really about my case, and they don't even know, and didn't my ex look at this, and all of that. So it becomes even more dramatic, and they could be ridiculous questions that have nothing to do with anything, but are just designed to inflame the emotions of the other side. So if you have an arbitrator who really wants to resolve the case, you're only going to be asked the questions that matter.
And the arbitrator can streamline the discovery and say, wait a minute, what are the 200 interrogatories with subparts? Why are you asking what color the house is? Do we care what color the house is? Why do you have 20 interrogatories about a business? Nobody owns a business in this case. Because, just the process of discovery can be very expensive. You issue the interrogatories, the client's got to answer them. The lawyers then got to look at them and decide whether you need to make objections, whether they should have been done differently, whether the answer isn't complete. I mean, they take a long time. And so people, when they get, the 200 interrogatories with subparts, the first thing they generally do is call the office and say to me, seriously? Did we send the same amount of questions to them? If we didn't, can we please do that? Go revise your interrogatories, please. Why? As opposed to an arbitrator who says, let's talk about the issues and let's figure out how many interrogatories do you need. Let's figure out how much discovery you really do need. What documents might you need? And they're supposed to, pursuant to, at least under the APDRI, which we use now, you're supposed to complete discovery within 60 days. That never happens in a litigated case that I have. It never happens, and so it just allows for a much more streamlined process, because the other part of it is you're having the conversations, you have a case management conference with the arbitrator who has the time to do this. And you can ask questions like, like my client asserts that her IRA is premarital. Right? Does the other attorney, does your client object? Does he contest that it's a premarital IRA? No? Great. Let's move on to a different issue.
Right.
I mean, I don't need then I need no discovery on that. It's done. Like, great. Thank you. I mean, do I need 6 years of credit card statements, or do I need 2 really for what I need to look for? You can really handle the process, and the clients have much more control at that point, in my view. They really have much more control of what this process looks like than they ever are going to do in a litigated process, because the process is the process there. And so it's just much better.
So then tell me, what do you think needs to happen for New Jersey to up its game and try to add arbitration to sort of its menu of options in divorce?
So I would say that it's starting to gain more traction because of the backlog. There are a number of lawyers that I know that have really shifted much of their practice into arbitration, where they are the neutral and the arbitrator. But I think the honestly the way it's going to happen is if we can get the UFLAA adopted here, that will be helpful.
Mhm.
And I think if litigants, if people, the public come to their lawyers and say, well, what about arbitration? And ask, and people discuss it. And then people start to use it. I think people are afraid of it in part because they say, well, but you can't appeal it. You can't appeal. An appeal, to me, if you're not giving anything up with it without the appeal. First of all, there's always the ability to overturn the arbitrator's decision if they've completely exceeded their authority. That's out there. But an appeal is not such a big, win for anybody. And so you're not really giving up a lot for what you're gaining in terms of being able to resolve things. I think people also need to start thinking more creatively. And this is, other members of the bar, and I've had this conversation with many people, seem to think that arbitration is this all or nothing. You're either arbitrating the entire divorce case or we're not arbitrating. Okay, but what if you have a prenup in your case and the two sides are fighting as to whether the prenuptial agreement is valid or not? And you're going to have to answer that question before you can even get to the resolution of the rest of the case. So are you waiting for a judge, 3 years for a judge just to decide that issue? Why can't you arbitrate that issue?
Right.
And then you can move on to the rest of the case. How about the issue that's holding up the entire case is whether or not this asset is subject to equitable distribution or is exempt, and the parties are fighting about it, and there's some testimony and facts and things that need to be decided, but we can't settle the rest of the case because we can't get beyond this. Arbitrate just that. Probably 3 hours of arbitration time and get a decision, and then move on to the rest of your case. You can probably resolve the rest of it in mediation if you can't finish arbitrating. But try to pick what those small items are and don't think of it as an all or nothing. And think of it in cases like I just said before, post-judgment cases that I don't know that you will, but I don't know how soon you're ever getting a hearing. We don't have the resources.
So then what you're really saying is that arbitration can be an excellent tool on single issues within
Absolutely.
larger cases. So if people are afraid of arbitration for the whole case, then view it as a tool for single issues within bigger matters.
Yes, exactly. Perfect,
So-
Lisa. Said it perfectly.
Right? So then this is a way to start access to arbitration.
Yep.
And where there are cases where like people leave open issues, maybe this suggests that we shouldn't leave open issues.
No.
That open issues only sets us up for more conflict later.
Yeah. That's completely true. I mean, I say to people all the time when I look at agreements, sometimes I say, can we not try to resolve this? Because all we're doing is telling these people they're going to be back in 5 years, 10 years, 15 years to litigate all over. And I'm not sure this was a great experience for them the first time after they spent $200,000, maybe more,
Right.
trying to get just divorced. I said, when I try to explain to clients and I try to tell people, I try to work this into agreements now. If you have a post-judgment issue, agree to arbitrate it. Please agree to arbitrate it.
Yeah.
I say to them, listen, if you think the mediation worked well for you and you want to go back and you want to try that for a session or two or whatever, don't get mired into mediation. What I say, sometimes people get, we go to mediation and mediation just drags on. I'm like, go to mediation for 1 or 2 sessions. And if that doesn't work, then just agree that you're going to arbitrate it because it's just going to be done so much faster. If I can't get some sort of process or parameters by which we're going to resolve it so that it's not really an open issue, then let's find the process that ends it quicker and more efficiently, privately with somebody who has been handling family law for a number of years. I mean, let's try to find a better way to do that.
That sounds really effective, right? If we're talking about making the system more efficient, more effective, which is ultimately more compassionate, right? Like people don't think that arbitration is compassionate because like that's an iron fist. Like they think about it like I think about it. Arbitration and unions. That's what I think about, right? It's like
Right.
a union tool. And how can like unions be parallel with families? But essentially, arbitration is about decision making. And if you can make a decision more quickly, that is more compassionate. You know,
Yeah.
if you have to take a decision, if a decision takes 3 years versus a decision that can take 3 sessions, it's quite different for that family experience.
Yeah.
Even if
And
the
by
decision, even if the decision doesn't come down the way that you had hoped,
you
you
have a
actually
decision.
you have a decision and you learn how to live with it. And I'm not talking about like custody decisions. Like, I don't believe that a custody decision should ever be 100% final. I
Or
will
not.
listen, or, you know, I don't know. Like, I can't say
No,
one way or the other. But the thing is, children grow up, right? Like at 18, there are things that change. So I'm gonna sort of pull that back. There are always circumstances, but at the same time, you need to be able to have some decisions made in a divorce so that each partner can move forward. That's what coaching is about, right? Moving
right,
forward. And
right.
you have to have boundaries and frameworks.
And the problem is that if you don't have a decision, I mean, the arbitration process can take place 3 days, like Monday, Tuesday, Wednesday, and be done. Not September, October, November, half a day each month. Nope. I mean, 3 months later. And you get a decision. And if you've picked somebody who has been practicing family law for 20 years, it's probably going to be a pretty good decision with somebody who knows what they're doing and has been doing it for that long and has either been a litigator or has been involved because they understand what the law is and they're going to think about it and be much more, thoughtful about what that resolution is. And one of the differences for New Jersey is we can arbitrate custody cases. I mean, many jurisdictions cannot, but we can. And custody is always, these are children. If there's a change of circumstance, I'm just making the decision in the moment. The arbitrator is just making the decision for now. If something occurs differently with respect to children, there's always going to be an ability to review it because the system's always going to operate in the best interests of the children.
Right.
But you can say, in the event there's a change in the future, the parties will arbitrate it.
Right.
I mean, I draft prenuptial agreements, and my prenuptial agreements now all have a provision that says, in the event of a contest of this agreement, you're arbitrating it.
Well, that's because you understand the power of arbitration.
Yeah. And I understand the reality of the backlog and the overwhelm in the system.
Yeah.
I mean, if the idea is, and I agree with you, I mean, you and I talked about this, nothing gets better with age. These cases don't get better with age. People things happen that shouldn't, emotions get triggered for whatever the reason may be, intentionally or not intentionally. And, children are in limbo. They don't know what the ultimate outcome is going to be. And it just gets, it just from an emotional standpoint, and frankly, from a financial standpoint, it just gets worse.
Yeah.
I mean, I always say to my clients, I've had clients over the years who have said, hey, well, I'm really due that $20,000 from XYZ account and whatever else. And I look at them and I say, and I used to do this years ago. I'm like, see, this is a picture of my daughter. It's my job to put her through college, not yours. But if you want to spend $20,000, $30,000 to get 5, I'm going to tell you, I don't recommend it. And so could you live? You're angry about it, but could you live without fighting over the last $20,000, be done and move on? And often that conversation, when we have that conversation, it's sort of like clarity sets in and they understand it because, you're going to, at the end, 90% of people are going to make a rational decision. I'll leave room for people who are just never going to, they're just going to fight for whatever. But most people at the end of the day are going to look at what the financial pros and cons are, the emotional pros and cons are, the impact to the family.
Right.
In the long run.
And the last thing that I'll mention just for today, because we have a lot to talk about, that when things drag on, people wind up making decisions just because they're exhausted.
Oh, yeah.
And so they will make decisions that are against their interest
Yep.
just to be done. And then they will regret those decisions for a long time.
Yep.
And that regret and resentment will also impact the relationship going forward.
Correct. I mean, I think I told you the case recently. In the last 3 months, I had a client who called me and said, end it, just end it. I don't care what he'll give me, end it. They had no kids, thankfully, not a long-term marriage, but I spent a half an hour trying to talk the client out of it. And it was, I hung up the phone and I burst into tears because I said, this is not how this is supposed to work. And I felt awful for this client. I understood why. I completely understood why. They were just done. But at the end of the day, that's, litigation fatigue, which is what I call it, is not what is supposed to settle cases.
Right. Which is why we need a reboot. And
we absolutely need a reboot.
And that's what we're talking about. And so maybe the reboot is arbitration. And this is the first time that I've had this kind of fulsome conversation about arbitration on this podcast. So thank you so much, Carolyn.
You're very welcome.
How can my audience get in touch with you?
So you can get in touch with me at my firm. I'm at Cohen Seglias. And so you can find me at CohenSeglias.com. If you go to the website, I generally tell people, if you Google my name, Carolyn N. Daly, Daly, Esquire, New Jersey, you're probably going to find me. And you're going to find I'm on LinkedIn. I'm on Instagram. I'm not on Facebook. I didn't do a professional page there, but LinkedIn and Instagram, and you're definitely going to find me if you just Google my name. So it has been a pleasure. I am glad to start discussing a reboot. I say to people, maybe it's a system beside the system. Maybe it's a system beside the system that starts to help.
Yeah, it's a great idea. Thank you so much. And to my audience, I will see you next week on Wednesday on Dishing on Divorce Next Chapter. And you can find me at Lisa Lisser or Lisa at lzlcoaching.com. You can always book a free discovery session right there on my website, lzlcoaching.com. And you can find me occasionally at lisa.z.lisser on Instagram. And I am on Facebook. So I will see you next week. Have a great week, and we'll talk soon.
Thank you, everybody. And thank you, Lisa, for having me.
My pleasure.